Good morning, everyone. Thank you for joining us. My name is Mahesh Rangaswamy. I'm with Thomson Reuters, responsible for digital court strategy. Really excited to have you all join us to hear some stories from the field. And we titled our program "Meet the Reformers," and do a quick introduction of who you're going to be really hearing from today. We have two of our esteemed customers and colleagues who are here with us. Karen Gorham from New Hampshire, she's the Superior Court Administrator, and Ms. Cecilia Rodriguez is the Court Administrator for Webb County Court of Law 2. And Judge Nicastro is going to be joining us as well remotely because she was not able to be here in person with us. Today we're going to hear from how our courts have handled the backlogs during the pandemic. That's really the gist of the story here that you're going to hear from, how they've leveraged technology to do that. So that's the gist of the story, and I'll just quickly run through a little bit of the program that you're going to hear from and how I'm going to structure the conversation today. So I'm going to start out, give you all about 10 minutes or so of some information and some statistics that we have learned over the course of the past 2 to 3 years. How have our court systems really managed through the backlog? And let's put some numbers around it in terms of what is causing some of the delays in our justice system. I'll talk about that to set the context, and then we'll hear from Karen and from Cecilia and from Judge Nicastro with respect to how they've implemented processes and technology to really help them manage through the backlog. So that's really the gist of what we're going to hear about today. From a Thomson Reuters perspective, we as a company are very committed to improving justice outcomes. We have technology capabilities that we deliver to our entire justice system, all the way from law enforcement to the courts. And we believe in the mission of improving the outcomes. And to that end, we even have changed or adapted a new mission statement for the company, which is to inform the way forward with justice, truth, and transparency. So we're doing our bit to take this very seriously and make sure that we're helping you all do better and improve the outcomes. That's me. I'm going to skip past that. And over the next 10 minutes or so, there are a few things we'll talk about. One, we want to give you an idea with respect to some data analysis that we conducted with the help of National Center for State Courts and some of our customer data to set the stage for what do we mean by where is the impact and what are we seeing in terms of the trends. We'll talk through that. We'll talk for a few minutes about the impact on people and cost and some recommendations, and then those recommendations are going to flow directly into the conversation that you'll hear from Karen and from Cecilia. Great. So how do we go about collecting the data? So there were two reports, multiple reports actually, but one of them coming out of the National Center for State Courts, the Criminal Case Management Project was one of the main areas that we looked at. There was about 1.2 million cases that were looked at a high level, and this was a meta-analysis, so it was not going into each individual case, but looking at the trends at the high level. 1.2 million cases, 136 courts, and across 21 states. So this was a pretty large data set that was used to really cull out some of the information that we're going to talk about today. We get some proprietary information from our customer base, from Arizona, from Texas, from New Hampshire, that we then use to also shed some more light on what is really the cost of delaying justice. What are our courts dealing with? And the other thing that is sort of significant here to understand is we're really going to talk a little bit more on the criminal justice side of the fence, not so much civil litigations, because we generally tend to focus on that because that's where the big money is. But the criminal justice system is just as important, if not more important, because it does impact all of us from a societal perspective. So we'll talk through that a little bit. So that's a basis for what you're going to hear about today. Some number play here for us, right? And most of you probably are familiar as court administrators. The National Center for State Courts came out with some model timelines for felonies and misdemeanors. And I talked about the 1.2 million cases across the 130 courts. Those had to do really with felonies and misdemeanors. That's what we're really going to talk about today. So the statistics are based on those two case types. The model from from NCSE for a felony case to get to adjudication is about 365 days. And it's about 180 days for misdemeanors. And a target of 98% was set just so we can measure how well we're doing. Are we actually going through the case volume and case processing approach? Over the last 2 years, nowhere close. So if you look at felony cases, it's only been 85%. So there was 15% of the cases that did not follow these models. And on the misdemeanor side, almost 35% of the cases did not hit the targets. And if you think about what that really translates to is how many number of cases A, didn't get heard or were continued, or the people did not get their day in court. That's why we're calling it a delay in justice. People did not have an opportunity to get in front of the judge, have the motions heard, and their case dismissed. So this is a real problem for all of us, and this has a direct cost impact. So that's the nature. We talked about felonies and misdemeanors and sort of the gap that's existing there already. And if you think about the scale of the problem, the scale's pretty massive too. So almost 57% of everyone that we talk to, and also the data that is showing, is the caseload is continuing to increase. So it's not that it's going down. The pandemic, of course, changed everything for everybody. Same thing with justice. So that you have an increase in caseload that's not going away. And then if you look at the number of criminal cases that are open or remained open since early 2020 going to 2021, there's approximately 400,000 cases, broad numbers. And that's a big number of cases that we're dealing with. And at the local and the state levels, once again, the number of cases in the backlog has gone up anywhere from 15 to 30%. So it's putting a strain on the system just across the board. So these are some real hard numbers for us to take a look at and say, how can this be improved? What can we do here? So those are numbers. Those are the number of cases that we're dealing with from a processing perspective. Let's talk about the human element and the cost element a little bit. Pretty much everyone who's dealing with the criminal justice system is impacted, from victims all the way to the courts and prosecutors, and I'll talk about that a little bit here as well. So speaking of victims, the biggest thing that is happening is we've lost faith. We've all heard justice delayed is justice denied. From a victim standpoint, that is a very real story. We're losing faith in the system, and we're not even showing up to have an opportunity to resolve a case. Fear is setting in. We're afraid. What if my assailant is still out there? So there is that part of it. And then if you take that and go one level deeper from a prosecution perspective, prosecutors now are dealing with case volumes and case loads that I think it was Georgia, in the state of Georgia, there's approximately one jurisdiction specifically had a 50% turnover of prosecutors, only because they couldn't deal with the case volume that was coming at them. So that's a real issue. And then the court of public opinion comes into play. So you got a whole other issue that is starting to take shape. So you have a prosecutorial issue because of workload and fatigue setting in. You have victims who are starting to feel that they're not getting their day in court. And NPR reported in 21, and it was in August of 2021, that prosecutors were just getting rid of cases because they just couldn't deal with the backlog. So you can see the trickle effect of and implications of something like that happening on a consistent basis. So that's the victim side of the story, pretty grim. And then you move over to the defendant side of the story. It starts with breach of rights. So I'm in remand, I'm in prison because I'm not getting my day in court because of the delays. So you have a constitutional issue, and I think we all are pretty familiar with what happened during the pandemic. I think it was about 3,000 plus prisoners who lost their lives due to COVID in jail. So that is another real problem. One of the stories that we picked up, and it's pretty well published, is in San Francisco, the public defender actually filed suit against the Superior Court on behalf of about 400 prisoners who were in jail for 9 months. That's a long, I'll just leave that, let that just hang over there. That's a real issue where you did not get your day in court, and it was also becoming a situation where the vulnerable population was pretty much taking a guilty plea just to get out of the system. So around just the entire system was starting to really fracture, if you will, because of the delays that were happening. So let's talk about the cost of the delays. So we work with New Hampshire. We work with some of our other customers to understand what is the cost. Can we put a dollar figure against what this costs us, and why? How do we measure it? So the first thing that we looked at was continuances. So typically, in any particular case, a continuance is the one that causes everything to restart again. So we focused our attention on continuances, if you will, and we came up with a number of $128. This is resources, court resources, the time, prosecutors, law enforcement, everyone's involved in that. So we figured, okay, so if it's $128 for each continuance that is coming into play, if we look at the average number of continuances for felonies and misdemeanors, if we go back, we said we focused our attention on just two case types. So that's 3 continuances on the felony side, 2.2 on the misdemeanor side. This starts adding up pretty quickly. So you're talking a few $1 million of money that is being that could be savings that could happen for the jurisdictions. And then if you add in the jail time for people who are not able to get their day in court and being held in jail, that's a staggering number. That's about $100 a day for a jail bed. All in all, you're talking about a total of about $10 to $12 million of savings that can happen. Not all of this can be avoided, but a lot of this can be avoided. And that's really what we wanted to share in terms of what we have learned in bringing that backlog down. 2 big things, a lot of things that you all are doing today. One is electronic filing. We all know the value of that. I don't think you should stop doing that. The other thing that is really becoming important is the ability to interact with the court digitally for your trials and for your hearings. So digital evidence, use of remote technology for using Teams, Zoom, whatever have you. Those are trends that are already there and definitely showing a lot of promise. And you'll hear from Ceci, I'm going to skip through the slide, about how the court down in Laredo was able to bring a backlog to 0. And we'll also hear from Ms. Karen on how New Hampshire has adopted some of the more leaner principles to bring the backlog and manage through that. With that, I'm going to now turn it over to hear from Karen.
Thank you, Mahesh. Good morning. My name is Karen Gorham. I am the Superior Court Administrator in New Hampshire. And in New Hampshire, we have a unified judicial branch. We've got 11 superior courts in 10 counties. Prior to becoming a court administrator, I had been a prosecutor for 25 years. The county I prosecuted for in California was larger than the state of New Hampshire, both geographically and population-wise. So that was a big change for me. But fortunately, I embrace change. I look for change. I look for efficiencies. I look for how we can do things better. And I know Mahesh talked about the pandemic and how we respond to the pandemic, but I want to talk to you for a few minutes about some things that we did in New Hampshire prior to the pandemic that I think really helped us get through the pandemic without creating a huge backlog, and we were able to institute some things and pivot fairly quickly to some new ideas to help things continue moving through the pandemic. I've been the court administrator for about 6 years in New Hampshire, and in the state of New Hampshire, the state sponsors what's called LEAN programs, and I don't know how many of you are familiar with LEAN, but I fully embrace LEAN. It is a project management tool that allows you to take a look at your current way of doing whatever it is that you want to lean. You evaluate the current process and look at what you can do better. What can you do more efficiently? What no longer makes sense in what you're doing? So the first LEAN project that I did as administrator was one of our courts continually had a backlog in the clerk's office, which of course leads to a backlog in cases. Routinely over 600 cases on the workload report every month, which meant orders were not going out. There were 600 orders to go out, hearing notices to send out, cases to schedule, work to be done that automatically leads to delays in cases if it's not done efficiently. So we did a LEAN project on the clerk's office. And we took the 600 case backlog, we changed everything that they did. It's one of our older court buildings. The layout of the office was inefficient. The layout in the office had everybody in the clerk's office looking at the window, so that when someone came into the clerk's window for the public, and when someone came to the window, whoever made eye contact first is the one who got interrupted from their case processing and went to the window to help someone. So we just re-engineered the court. We put all of the employees in the back and a receptionist in the front to handle everybody who came to the window. During that process, what led us to that is just a time study. We took one of our very effective case processors, had him work in the back of the office and track what he got done in one day. Then we had him come back to the front of the office, 1 week. We did them both for 1 week. Had him come to the front of the office, and with the interruptions and the people coming to the window, he accomplished 3 times the work when he was sitting in the back of the office. So that told us we need to fix that. We fixed it. That clerk's office has been on top of all of their case processing ever since. And part of it for me was as an administrator, I had court staff coming into a court every day looking at 600 files on a wall and working hard all day, every day, and never seeing the pile get any smaller. And that can be so demoralizing for a team. And I needed to fix that for the length of time it takes to get a case done, and for our court staff to give them the tools to come to work and feel productive and feel good about what they're doing. And they've been a great office ever since. So I'm a huge fan of lean. We've also leaned small projects. We've leaned, we implemented civil e-filing, criminal e-filing, and prior to implementing both of those electronic processes, we leaned our entire case processing to incorporate those efficiencies into what we were developing electronically. One of the things I did want to mention with Stratford County, and I forgot to talk about, is I was absolutely stunned when we mapped out the way that Stratford County was doing things initially, their current status. We found that when a piece of mail came into the clerk's office, it had 8 touches before it was put in the case file and entered into our case management system. 8 people touched a piece of mail. That's a waste of time, a total waste of time. So with the lean process, you look at where the waste is, and you constantly, you're looking for that continuous improvement in your processes. Some of those changes will require protocol changes, rule changes, admin order changes, and we're not afraid of doing that in New Hampshire. The other area that the pandemic really pointed out, one area that we were operating very inefficiently were in when law enforcement needed a search or arrest warrant. Our process in New Hampshire was that law enforcement prepared their paper documents, they brought them to the court. If there was a judge available in that court, the judge would review it, which meant someone in our clerk's office had to go find a judge, figure out what their schedule was, determine if that judge had time to sign a warrant. Our larger courts got more warrants because they're in the bigger cities, so those judges were buried. Our smaller courts in the more rural counties maybe saw a warrant once every 2 weeks. We wanted to balance the warrant work, and we wanted to make it more efficient for law enforcement, so we now receive in November of 2021, maybe 2020, the whole timeline of the last 3 years is lost on me. But we implemented an electronic warrant process. I didn't have a budget for it, I hadn't planned for it, but when the court clerk's offices were closed to the public, law enforcement couldn't get their warrants to the judges, so they started emailing them, which is not CJIS compliant, which is not a way we should be receiving confidential law enforcement information. So we needed an electronic process that was CJIS compliant, and I had no money. We were able to come up with a system using the federal FBI law enforcement enterprise portal, using one of their products called Teleporter. And law enforcement now sends their warrants in to a central location. We have 2 warrant clerks for our entire state. They send their warrants in, it's a CJIS compliant method. They go to a judge's queue, and our judges are used to working electronically because all of our case types are now electronic. Goes to the judge's queue, the judge reviews it, annotates it, and our warrant clerks then send it back out to law enforcement in a CJIS compliant manner, and they have their signed warrants. One of the roadblocks when we were developing this process was that warrants are required to have an affidavit of probable cause. An affidavit could not be electronically signed. We did have a statute in New Hampshire that allowed electronically delivered documents to have a statement under oath, under penalty of perjury, with an electronic signature. But our warrant statute required an affidavit. So I went to the legislature, requested that they remove the affidavit language, and now our warrants are signed under penalty of perjury under the electronic oath statute. So it did require some background work with the legislature, but we were able to accomplish that, and we now have all of our warrants distributed evenly among all our judges in the state with one central location for all of law enforcement to submit their warrants. I have on this slide to address issues collaboratively. Whenever we implement change of this magnitude, and it requires a lot of training, a lot of changes, in New Hampshire being a rather small state, we do everything collaboratively. That doesn't always work. When we were implementing our criminal e-filing project, the easiest hearing in a criminal case, at least from my perspective, is the arraignment. You're just notifying the defendant of the charges and scheduling a next hearing date and maybe addressing bail. Should be a very easy hearing to conduct. We had more problems. We had a group of public defenders, a group of private defense attorneys, prosecutors, all trying to come up with the arraignment process. We came up with something that we thought was going to work electronically, and then when we went live, it failed miserably. You know, the non-incarcerated arraignment sessions are fast-moving. There's a lot of people. Attorneys are getting appointed, and it simply didn't work. We had to completely revamp our collaborative process after we went live. And part of collaboration, as I put on here, is communicating with the bar. Anytime you implement change, you're going to run into this. People who may look at your leaned project, the before and the after, and say, absolutely, this makes sense, but you're moving my bowl, and I don't like that. When we did our criminal e-filing project, one of our courts in particular, that was a very well-performing court, called me and said, why do we have to do this? Our numbers are great, we're on top of everything, why do we have to do this? I was moving their bowl. So I made them our pilot court and worked with them, got feedback from from our employees about what works, what doesn't work. We made changes. And I learned right before I came to this conference that the criminal supervisor came up to her court clerk and said, don't tell Karen this, but I really like e-filing. We don't have to look for files anymore. So even though we moved our bowl, we worked with them and we got through it. But this is real. It's real. And you have to be very cognizant of that when implementing change. You also have to be cognizant of the outside forces. I think as Mahesh mentioned, you know, a prosecutor's office losing people. In New Hampshire, we have a very real problem with our public defender's office, losing attorneys during COVID, having a hard time hiring and recruiting public defenders. And we are able to work with them and try to figure out what's going on. We're actually recruiting attorneys from Massachusetts to come up and handle conflict cases because we don't have public defenders to appoint. In order to do that, no Massachusetts attorney is going to want to spend 2 hours driving to a court in northern New Hampshire for a 10-minute dispositional hearing. So we had to promise them that we would do remote hearings, or we would do hybrid hearings so that they wouldn't have to spend that time traveling unless they needed to meet with their client. So we do what we can to make things work, and usually it does. One of the other things that we did when we rolled out our oh, sorry, let me go back. One of the other things that we did when we rolled out our e-court process was we specifically excluded exhibits from e-court because we didn't have the courtroom technology that would allow the presentation of exhibits. We didn't have a manner in which the exhibits could be submitted electronically. But like I talked about earlier, lien requires continuous improvement. So phase 2 of our e-court rollout is now, we're about halfway done with our state. We're rolling out county by county case center, the digital evidence management system, because what we learned during COVID is if you have a remote hearing and you have evidence, where does that evidence go? How does that get to the court? How do documents get sent to the court as an exhibit? We were all over the board. Some attorneys would mail the documents in and then they may not show up in time for the remote hearing. Other attorneys were emailing the clerk's office, and then the clerk may not get the email or may not open the email and get it to the courtroom in time. It was a real problem that we needed to address. So that forced us to look into a digital evidence management system. And we selected the Case Center product, and we are in the process of training our monitors and working them into what our hybrid hearings are looking like now. We had a bench bar conference a couple weeks ago, and all of the attorneys love the idea of a hybrid hearing, but they don't want to be the one appearing remotely because of the fear of missing out of what's going on in the courtroom. So we're working on trying to fix that issue right now, and try to enhance our hybrid hearings so that attorneys feel comfortable appearing remotely because it saves them so much time and so much energy. So addressing the backlog that we did end up with in New Hampshire, even though I felt that we were very well situated, a couple of things that we did is, when you develop a big backlog, you really hope that a lot of the cases are going to resolve by way of a negotiated settlement, both civil and criminal. We hosted a negotiations training with all of our public defenders and our prosecutors. We hired an expert to come in and he did a day of evidence-based sentencing. We recorded it, and I'm still getting requests from civil lawyers and criminal lawyers for copies of that recording that talks about interest-based negotiations and how to effectively resolve cases. We also then followed up with an in-person workshop where we had a team from the Harvard Negotiations Clinic come up and work with parties and did mock sessions on how to resolve the more difficult cases. That hands-on session was very well received. It was necessary because of the turnover in a lot of the offices. A lot of the new attorneys came on and had a huge caseload that they were inheriting, and they needed to learn how to negotiate and resolve cases, so it was pretty effective. The other thing that we did is we've always had a felony settlement conference process, which is pretty involved. All parties have to agree to go to felony settlement conference. Usually there's fact memorandums that are prepared, and pleadings that are prepared for the judge who's going to handle that felony settlement conference. We wanted something that was quicker and faster, but getting the same results. So we developed a criminal mediation program with some of our senior judges and our Chief Justice. Only one party has to agree, or it can be the judge that refers the parties to a criminal mediation. We schedule them every day for between 45 and 60 minutes, and we've resolved 95% of the cases that go to criminal mediation. It's that dedicated time of sitting down and talking about one case, learning what each party is really interested in for either the sentence or the civil settlement, and letting the judge talk, weigh in, but it's really about getting the parties together. In a committee that we established during the pandemic, the Resuming Operations Committee, Return to Operations Committee, whatever we called it, we had a bunch of attorneys that we would meet with on a monthly basis. And one of the things that both civil and criminal said is, we don't see opposing counsel walking down the hallway, and we've lost that ability to communicate with people working remotely, not coming to court. We don't have a chance to talk about our cases. You can email back and forth with offers and counter offers, but it's that face-to-face. We wanted to give them that face-to-face through the criminal mediation program, and I think that's probably why it's been successful. The other thing that Mahesh had touched on is the cost of delays. How do we reduce the harm because of delays that are inherent in all case types? One of the things that we were ready to go live right before the emergency orders shut down the state of New Hampshire with our text messaging program in criminal cases. So we're actually going to go live on that hopefully within the next 2 weeks now. We did a demo or a pilot in our family mediation cases of text message reminders, and it reduced failures to appear by 40%. So we're hopeful that in criminal cases we see that same type of result. The other thing that we learned is that if a defendant leaves the court with their next hearing date, they're more likely to appear. That's what the studies have shown. So we've gone to giving our staff that are in the courtroom set times to schedule a dispositional conference or a trial so that they can give the defendant the paperwork when they leave the courtroom. Obviously, sensible bail decisions. Bail reform has been a huge issue in New Hampshire with our 400-person legislative group deciding, and they're elected for 2-year terms, so we'll get, we've had both sides of the pendulum regarding bail reform, so we have to work with it and hope for sensible bail decisions. The early appointment of counsel, we have, most in New Hampshire, and I don't know if this is common in all states, but most of our defendants come to court wanting an attorney, but not having completed a request for a lawyer. We changed all our forms, so instead of a financial affidavit that's 4 pages long and looks like a tax return, we've got a simplified statement. It's called a request for a lawyer, so they know exactly what they're doing. We're still not getting them early enough. More often than not, they're coming to court for their arraignment and requesting a lawyer. So we're looking at different ways to get counsel appointed earlier. But of course, with our public defender shortage, I'm not sure we're going to make any headway until that issue is resolved. And limit the number for opportunities to fail to appear by only conducting hearings when they're necessary in a case. A couple just final things that we did, just small innovations that have been pretty successful, is that whole idea of parties not seeing each other in court and having an opportunity to resolve cases. All of our counties have been now doing a prosecutor of the day, where one prosecutor will take all of their cases, be available to negotiate, and defense attorneys will come in and negotiate cases. The very first day we did a prosecutor of the day was they resolved, I think one attorney resolved 45 of her cases. What I promised is if any of those cases are ready for a plea on your prosecutor of the day, we will have a judge available for you to take that plea. So we have a rotating schedule of judges available. They take the pleas remotely. And the case can just be resolved that day. And a small change that we made were on misdemeanor no time dispositions. We now have a court rule that allows those to be filed, the sentencing paperwork and the acknowledgement and waiver of rights to be filed electronically, and then we have a judge review them on paper. So there is no court hearing necessary for a misdemeanor no time plea. And that, a lot of our felony cases do resolve as misdemeanors. Oftentimes, it's either a time served or suspended time plea, and those can all be done on paper now without a hearing. So that idea of avoiding hearings where they're not really necessary, looking at your case flow and figuring that out is something that we've spent a lot of time on. So that concludes my presentation, and I think at the end there'll be an opportunity for questions. Oh. Now or wait until the end? Are there any questions? Okay, well that takes care of that. So, okay.
Thank you, Karen. It was very enlightening to hear sort of the mix of process and technology. That's really what we got from sort of how New Hampshire has approached this. And now we're going to hear an even more fascinating story from Texas in how a small court in Laredo was able to bring their backlog to zero. With that, Ms. Cecia, over to you.
Thank you. Hi, good morning, everyone. My name is Cecia Yamez Rodriguez, and I'm the court administrator and interpreter for Webb County Court of Law Number 2. And thank you so much for being here. I'm delighted to be part of this panel and representing my court. Today, I will share with you the changes that our court has effectuated by using case management and technology to first cut the typical backlog of over 6,000 cases in 2017, and again, eliminate a backlog, the pandemic backlog, in May of 2022. The following presentation will give you an insight into our court's background, where we were, how we got here, where we are at, and where we are going. Webb County Court of Law Number 2 is located in Laredo, Texas, and it is on the U.S.-Mexico border. We are a bilingual and bicultural community in the 10th largest city in Texas. In April of 2017, Judge Villarreal inherited a court with a serious backlog known for its lack of transparency, constant delays, and audited as the worst in Texas for compliance with guardianship law. Due to a lax continuance policy, it took up to 5 years to conclude misdemeanor cases in this court. The backlog was such that the ADA was filing matters almost at the 2-year date of incident, leaving victims wondering when they would have their day in court. Defendants had pending cases that were not dismissed properly, even after no speedy trial, stale evidence, or the victim no longer wanted to prosecute or was nowhere to be found. In many civil and family matters, there were no final orders filed for 15 plus years. So Judge Victor Villarreal was selected by Commissioner's Court in March 2017 by unanimous vote, and then later elected in a contested race in 2018 to effectuate the much-needed overhaul and restore public trust, and is now, thankfully, running unopposed in 2022. Once in office, we reached out to the Office of Court Administration, and this is a state agency operating under the direction and supervision of the Supreme Court of Texas that provides resources and information to effectively administrate the judicial branch of Texas. We invited them to do an in-person, on-site visit and review our procedures, our files, and our court operations. I know that we have all heard this before. If it can't be measured, it can't be managed. So the case management system data, the OCA reports, and the clerk's docket reports showed that this court was in serious disrepair. So what we did is we took the data, and data is power, and we used that information and we executed our plan. And I'm gonna be real with you. It was a lot of data and it was daunting. But we scaffold our way to success. So we reviewed each physical and electronic file of the court for all dockets under its jurisdiction, and we set the probate, the civil, the family, the criminal misdemeanors, the juvenile, and the mental health cases pending disposition for hearing by notifying all parties and provided new dates if good cause was given. We would do so by e-service, by hand delivery, and mail delivery. The institution of scheduling orders and a new strict continuance policy and informal docket settings that give defendants a set time to discuss counsel and consider the plea offered by the state and or resolve discovery issues and exchange has resulted now in misdemeanors being disposed in 3 to 6 months. It now takes civil and family and probate uncontested matters 3 to 6 months to resolve, and it allows contested issues to be heard in each docket with sufficient time. As my fellow panelist stated in his presentation, there is a human and financial cost to delayed justice. I suspect not too many people know how much a continuance costs. So I ran the numbers for our court. Because remember, if it can't be measured, it can't be managed. So every continuance in a civil and family case, it costs approximately $375 per party. It cost the taxpayer approximately $350 in salaries for county personnel per 1 hour of court time. So in our court, trial dates are certain and the continuance policy is in force. This assists the court to allocate resources such as time, jurors, interpreters, court reporters for complex cases. No delays, no extraordinary cost to the taxpayers and clients. As the court administrator and court interpreter, the time that I spent in the courtroom helped me identify necessary technology and assess courtroom user needs. So during our first budget request to Commissioner's Court in fiscal year 2017-2018, we included hardware and software. We did so because good technology means the difference between judicial efficiency and case stagnation. Use of technology is ultimately in the interest of judicial economy and in the interest of justice. For our guardianship compliance hearings, we set 5 computers in the jury room and we assisted guardians to register with the state, which is now a statutory requirement, and they took their guardianship course. This proved to be successful, and by summer of 2018, we had achieved 100% compliance and to this day, we're the only court in the state to do so. I translated and provided all court forms in fillable bilingual format, which have proved to benefit the bilingual community that we serve. So we were evaluated by the Office of Court Administration on the following areas: court operations, access and fairness, data-driven case flow management, governance. Our work resulted in a typical case backlog and a designation as a Judicial Center of Excellence on November 15th of 2019, the first county court of law in Texas to achieve this designation. So, for the past 3 years, we looked for innovation, challenged preconceived ideas, and stayed open to reevaluate and reconsider our practices. We learned to focus on better practices. We don't focus on best practices because once you get to best practices, then you're done. You're never going to change. And we can always improve, right? That's why we're here. So unknowingly, our rethinking and reevaluation of our initial ideas prepared us for the pandemic and the future of the justice system. When the pandemic hit, the impact of closing down weighed heavily on the judge and the staff. Court users wouldn't be able to continue with their lives. Lawyers wouldn't be able to represent their clients and present their cases. If we shut down, livelihoods were at risk. Unable to hold in-person hearings and trials, the immediate question was, how will we deal with the jury trial backlogs we would inevitably experience? So, although it feels like a lifetime ago, let me take you back to early March of 2022. I'm sorry, 2020, not 2022. Judge Villarreal called a staff meeting and he told us about Zoom, a platform his wife was familiar with, and his purchase of a license. While we waited for the Supreme Court to give its orders, that Friday we took action and personnel were sent home at 5 p.m. with technology, supplies, and marching orders. Keep the court open. By 5:53 p.m., the Texas Supreme Court released its first emergency order, which allowed the courts to require anyone involved in any hearing to participate remotely, such as by teleconferencing, video conferencing, or other means. While people waited for that 2-week lockdown to be over, that spring break week, we announced the use of Zoom, did multiple run-throughs, we became acquainted with the program, we hosted Intro to Zoom webinars for attorneys and other courts around our state. On Monday, March 23rd, 2020, we held our first virtual hearing in Webb County. Let me ask a question. How many programs does it take your court to operate virtual court settings? 1? 5? 2? All of them. These are the ones that we use and why. Zoom, our virtual courtroom. Each tile represents the bench, the witness stand, the court coordinator, the reporter, the clerk, the interpreter, counsel, the court user. And when you're in speaker view, it's the well of the court when individuals are spotlighted. YouTube, our virtual audience section. The open courts mandate is a Texas constitutional requirement. And the public and court users can see any judicial setting, and the effect is increased public trust and confidence in the justice system. When this happens, we all win. We use Z-Connect. This program informs the courts the attorney login time. We mirror what we did in person. First come, first called. So court users come into the hearing identified by name and designation, such as attorney, party, or witness, not as iPhone user, Galaxy 123, or other colorful names that I'm sure you guys have all experienced. No need to change Zoom IDs, they do it for you. And we saved about an hour per docket hearing identifying people before and during the hearings by using this program. It also tells you if they need an interpreter because it has the page in English and Spanish. So when they log in, it'll say Spanish, and that's how I know, oh, this person needs an interpreter, and I don't have to be asking, necesito un intérprete. It's there, and I just start interpreting. We use WhatsApp or electronic Post-it note. We give the judge real-time information on attorneys, parties, witnesses, and people who are present in the virtual courtroom. Odyssey, our case management system. Duo Mobile is the county multi-factor authentication system to connect to the VPN so that we can do remote work securely. We use Google Drive, our interdepartmental off-network sharing of documents, those files that are too large to email. And a good example would be this PowerPoint. We use Adobe because we're a 100% paperless court, and this allows the judge and staff to electronically sign, text directly into the document, and we can convert from PDF to Word, spreadsheets, bait stamp, so much more. We use Westlaw because that way the judge has access to case law and statutes cited in open court settings. We use web browsers like Edge, Chrome, Firefox, and Safari to broadcast our hearings on YouTube, to access the online systems for e-filing and e-service through the Texas filing system, and to access our online evidence platform, Case Center. We do this, that way we avoid the potential of ex parte communication with the court by the court users. And Thomson Reuters Case Center, formerly Case Lines. So in March of 2020, when everything shut down, we resolved the issue of receiving, reviewing, and admitting evidence by creating an account on a free online cloud storage. So for each docket, we would create subfolders, and then we would give access to everyone involved in that case. And then we would send that link via email to everybody involved in that case. Then the docket would start, and at the end of the hearing, I would erase everything and start all over again for our next docket. I would spend 3 to 4 hours every day creating subfolders, getting everybody's email, sending the email, just to make sure that we wouldn't be ex parte, and that people could say, well, it's because I didn't have a chance. No, you did. We sent you the link. It's right there. So thankfully, 2 months later, we began using Case Center. It's a central online hub for court users to securely receive, review, admit, and present evidence. Parties and self-represented litigants can upload PDFs, audio, and video files via their smartphone or their computer. So if anybody has more than one case with the court, they will see their case list on their homepage of their user profile, and all parties, including the court coordinator, will receive a notification via email when there is an upload on a case. For example, a proposed plea, exhibits, or evidence. Now, this tells me, the court, that a case is close either to resolution or it's going to require an evidentiary hearing and we need to make time for it. The difference between using a cloud storage system and Case Center reflects the adversarial nature of our justice system. For example, in our cloud storage systems, they're meant to be collaborative. I can share documents with you. But the justice system is, however, adversarial. So Case Center allows for cooperation between counsel, not collaboration. Technology is your friend if you make it your friend. In our court, it's all about the court user experience. We polled our local bar, and 90% of lawyers want Zoom to continue indefinitely for uncontested hearings. There has been an increase in access to justice and access to the court. And if you have the same experience like I do, you know that more people attend court now than before, and less time is spent traveling to the courthouse, to the downtown, looking for parking. And time is something that court users are now spending either at work or with family. You also know that while counsel waits for the cases, they're working on other cases, which means more output, more invoices, and ostensibly more output for the legal system. We have made video conference court hearings user-friendly by troubleshooting in real time. So it's the court's policy that one must appear on video if they're testifying. And if there's no video, we prompt our connect to audio admonishment screen. And if that doesn't work, then we send people to a breakout room, we troubleshoot with them, and then the next case is called. So we're not spending time, you're not connected, or turn on your mic. And so everything is done in the breakout room. We also use court timers, and the use of timers is good for arguments. So for example, lawyers are not interrupted at your 5, your 2, or 1 minute marks. They can see on their screens how much time remains for their argument, their opening and closing statements. This provides for stability, uniformity, and fairness. Our experience is that the lawyers that talk the most get the most time. And by using court timers, we equalize the process and the proceedings. It gives everyone the same opportunity to be heard, and it's also good for recess or for standing at ease. So lawyers, people in the well of the court, the virtual courtroom, the witnesses, and even court staff now know how much time you have for your coffee, for your break, and maybe make that phone call that you're going to bill later for another client. On May 2022, Judge Villarreal announced the end of the pandemic case backlog. We accomplished it by setting matters that had announced ready for in-person trials and objected to the virtual ones on a new scheduling order. We hold a virtual docket control conference, and this informs the court of the efforts and strides that have been made in the case to resolve issues. Then we have an in-person jury selection conference to iron out any details. And then we go to voir dire the next week. The strict enforcement of these scheduling orders have given notice to all parties that the court is now ready and is able to safely hear their cases. No more delays, no more excuses. Now everyone gets to have their day in court. Winston Churchill said during World War II, "Never let a crisis go to waste." I know this is not the crisis that we wanted, but you know what? This is the crisis that we needed. It has thrusted the judicial system to the 21st century in the use of technology. While the rest of the world was already paperless, using virtual technology daily, the courts were stuck in paper. I come from the private sector, so when I went into government in 2017, it was like the agony of 1,000 paper cuts. It was terrible. Currently, the 52nd Texas Supreme Emergency Order allows the courts to continue virtual hearings until September the 1st of 2022. And I hope it lets us, or Texas, continues to use or allow us to use virtual court settings. So now we have started the hybrid hearings. We are connecting our in-person and virtual participants in a Zoom session. And we do it by connecting our court audio setup to the Zoom session. And then in our email reminders to everyone, we delineate the best practices to have a clear record. So walk up to the mic, make sure you enunciate. This is your record after all, counsel. And we place cameras to capture the judge's bench, the witness stand, the well of the court, the lower bench section, and the attorney tables. Now, our courtroom monitors that are located by the jury, the witness stand, and in each attorney table display the virtual participants and the digital evidence. Our mission is to provide safe and equal access to justice for all, fairly, and impartially, with efficiency and respect while promoting public trust and confidence in the court. I thank you all so much for your time and really look forward to your questions. Thanks.
Thank you, Sasya. It's always very inspiring to hear you speak about all the successes that you all have had over the course of the last couple of years. For me, personally, working with both Karen and Sasya as adopters of some of our technology that they talked about, they just jumped into it. They just made it work. They had to figure it out. We didn't have any other choice. And the results speak for themselves. Our next speaker was not able to join us here today. Judge Jabra Nicastro is a presiding judge from Garfield Heights in Ohio. Now, what you heard from Karen was sort of how a statewide approach in terms of process and in terms of technology has helped sort of smooth things out and manage the backlog. From Sasya, you heard a little bit more of a very focused effort. They had a backlog issue, they had a trust issue, and they had to do something during the pandemic. What we tend to forget sometimes is the criminal justice process is just not about the court. There are other people, law enforcement and prosecution and public defense, who have to work with the court in order to make the process flow. That's what you're going to hear from Judge Nicastro today, as to how she's used technology to drive a better discovery process within her court.
Hello, I'm Judge Jabra Nicastro of the Garfield Heights Municipal Court. We're there in northeastern Ohio. That's we're a suburb of Cleveland. Thank you for inviting me today. I'm sorry that I couldn't be in person. I'm currently at our Municipal Judges Association for the state of Ohio. Today, I want to talk about the Digital Evidence Center. The speakers before me probably touched on Case Center, but I'd like to go into how we use it here in Garfield Heights Municipal Court and why we use it to manage all our digital evidence. First of all, what is a Digital Evidence Center? It's an online platform. We use it to exchange evidence between the litigants. It's used to present that digital evidence to the court, and we keep it as our storage and retention center for digital records. It is not, let me repeat, it is not a repository for anything other than evidence. So no one can file their motions or other pleadings on Case Center. That has to be filed with the clerk of court in our online docket system, online filing system, and everything has to be filed with the clerk. This is just a repository for evidence used in each case. So we chose the Case Center by Thomson Reuters. During the pandemic, we were totally digital before the pandemic. All we had to do was switch to Zoom. We got a grant from the Ohio Supreme Court to do that. But the only thing we couldn't manage remotely was the exchange of evidence. Before the pandemic, all the attorneys would gather in our courtroom for pretrials. They would exchange flash drives, DVDs, anything else that needed to be exchanged. Well, that couldn't happen during the pandemic because we were operating 100% remotely. That exchange usually is the biggest delay in our criminal traffic cases and even civil cases sometimes when we're going through the discovery phase. So I was happy to find Case Center to use even now without the pandemic. It has really sped things along. We needed a system that was compatible with 10 law enforcement agencies and 9 prosecutor offices. We are a multi-jurisdiction court, so we have quite a few different agencies. I liked it because it requires no special tech people. We do have an IT administrator in the court, but we only have one person, and he's spread pretty thin, so we didn't want to add to his workload by having a system that had to be operated by a tech person. There's all online help. There's tutorials. There's explanations. They've got a chat. You can ask questions. So it really helps the litigants without calling the court to ask for help. It is compliant with all FBI security protocols. That was very important to the police chiefs that act in our court district because they want to make sure that things like the law enforcement database evidence is transmitted securely. There's over 500 evidence formats to be uploaded. You can imagine with 10 law enforcement agencies, 9 prosecutors' office, everybody has a different platform that they use. So far, Case Center has been compatible with all of them. The clerk loves it because it eliminates the storage of DVDs and flash drives. We don't have to test those things before we bring them into the system. It's just all uploaded to Case Center that monitors whether the file works or not. And Thomson Reuters complies with Ohio's retention schedule. So for a municipal court in Ohio, we have to keep criminal case records for 50 years. Thomson Reuters will have to keep that. Even if we discontinue service, they have to preserve the records. The process is incredibly simple, and this is what we do for criminal traffic in our court. The defense files a request for discovery in the clerk's office. That immediately triggers any reciprocal discovery under Rule 16. Also, at that point, upon receiving that filing, the clerk, or in this case, our bailiff now, opens a case in Case Center. An automated email is sent to everybody who is related to that case. The prosecutor, the defense attorney, the police in our case, who are the ones that upload the evidence, and or the prosecutor, both might do that. So what will happen is when they get that email, the opposing party immediately uploads any evidence. So the police in this case upload it. At that point, all evidence is available for trial or motion hearings. It can be presented, it's there, it's waiting, and all evidence is stored. This has really sped up our process. And just to give you an example, a few weeks ago, we had a situation where on the day of arraignment, the defense attorney, who's familiar with the system, filed a demand for discovery. By the end of the day, the police had uploaded the evidence. 2 days later, I had a motion to suppress. That process would usually take 90 days before using a digital evidence center, or this portal as we refer to it. The prosecutors like it because, first of all, anything that's uploaded, they can mark for counsel only, pursuant to Rule 16F. They control at the time of the hearing the submission of the exhibits and the order of the submission. If we're doing a hearing by Zoom, they share the screen, bring it up, and they control how it's submitted. They operate the computer themselves, either by a laptop or their own in the courtroom or on their own desktop if we're operating remotely. There's a private note function that the attorneys can use to keep track of where they're going as they work through the evidence. I also can make notes so that if I need to go back later in making a decision, I can refer to it. And of course, then when it's admitted, it's time-stamped, and then we can also mark that it's admitted or excluded. It's really beneficial to the litigants because, first, accessibility is 24 hours a day. You can access it on your telephone, your smartphone. I do that all the time. If I'm called upon to hear something over a weekend, we have the police upload the evidence directly to case lines, and I can go look at it if I'm doing bond settings. So that's a little outside the adversarial process. The link is shareable by the defense attorney, either by email or a text link, so they can send it to their client. In our court, we do traffic and misdemeanor cases, so we have a high volume. It's pretty fast paced. This way, and most of our litigants don't have elaborate computer setups, so they're working off their phone. And as I said, you can easily watch the videos or see anything else on your phone. So when the defense attorney sends a text link, all the client has to do is go online and look. The evidence, though, is downloadable. So once the attorney accesses it, they can download any digital evidence and preserve it. They can make annotations. Again, they control it at trial. They don't need a media or IT expert. It's so simple that it's just like playing a video on YouTube. That's how I kind of explain it to non-techie people. You just bring it up and click, and it plays. Of course, if you want to mark it, you can mark where you want to be in the video so you can access it quickly. How many hours have we spent in the courtroom as the attorneys are trying to go through a DVD and find the location they want to be? So they don't need a media or IT expert, and I don't need a media or IT expert in the courtroom. And as I told you about my story where a motion to suppress was up and filed within 3 days of arraignment, it's a very fast. And it really has cut down on the amount of pre-trials we have and the amount of time we're waiting for discovery to be completed. There's definitely benefits to the court. As I said, it reduces the discovery delays. It's instantly reviewable remotely or in the courtroom, and you don't really need special equipment in the courtroom. We have a laptop on our trial table. It's connected by cable to a monitor on the wall, and they just use it that way to present their case, whether it's to the judge or the jury. And obviously, if it's in Zoom, we use that platform, Zoom. You can share it on screen. No tech staff needed. We do not have to have every DVD or flash drive checked through our IT department to make sure, first of all, there's no viruses on the flash drive and that the DVD works, especially if you deal with a lot of police agencies. You know, they all have different software programs. And even though we're used to the agencies we deal with, many times we get DVDs that we just couldn't work. And certainly the defense attorney couldn't work. We don't have to worry about storage and destructions and indexing flash drives and DVDs. That's gone by the wayside. Those boxes stacked up in the clerk's office where I say to my bailiff, go find that DVD. Those days are over. He's very happy about that. And plus, it has all the security protocols that you could expect. Again, when I went to study this and decide whether we're going to go with Case Center, I had the police chiefs in my district review it. They were all satisfied with the security protocols. And as I said earlier, those records are there for 50 years. They'll be preserved. Of course, at some point we could download that evidence and preserve it some other way, but right now we don't have any immediate plans to do that. Thank you for your time and attention. I hope that you learn a lot today at your seminar. If there's anyone who has any questions, we are online at ghmc.org. Send me an email, info@ghmc.org. We'd be happy to discuss Case Center with you and answer your questions. Thank you.
Thank you. That was Judge Jabra Nicastro, and she took a very different approach in terms of how to solve the issue. You had a court's perspective, but she took a technology product and helped solve the issue for the prosecution and the defense by cutting down discovery time. So net, if you sort of bring the stories together, there are a number of different ways that our reformers have approached how to solve and reduce the delays in our justice system. So with that, once again, Karen and Cecia, thank you for your time, and thank you all for joining us. We'll open the floor to any questions. Yes, please.
Quick question, you're using WhatsApp on hearings, right? So in WhatsApp, do you have any courtroom, like setting virtual rooms concept in the WhatsApp, or just how exactly you did it on WhatsApp?
Well, we use it just internally for the court staff. So we created a WhatsApp group, and we have. Can you guys hear me? Yes. Am I enunciating? Oh, okay. So it's an internal use of it during our because you're not next to the judge sometimes. You know, everybody's in their own computer. And I don't know if you guys have maybe another program in your computer to chat with the rest of your coworkers. That disrupts the Zoom session. So what we did is of course, everybody has their own cell phone. Everybody knows their coworker's cell phone. So instead of it being a chat or messaging. We just used WhatsApp, and we did a court, group. And then we're just messaging each other like, hey, like this person is not connected to audio. I'm going to send them to the breakout room. And then somebody help? We are, a court that has more than one court coordinator because of the jurisdiction. So that's why we have a lot of us in there. But not everybody is in the Zoom session. But that way I can get help, when there's help needed. So that's how we use it. And then sometimes we'll also send messages to the judge, like, oh, I see that this witness logged in and they're in the waiting room. If he's like looking at it, or if they're talking about a case, the court coordinator will look at the case management system and be like, okay, this file was, or this motion was filed this certain day. Just little kind of Post-it notes that might not be on the docket or reflected on his notes before the hearing starts. So that's how we use it.
So like, if you have many participants, do you have any restriction on WhatsApp, like how many participants can?
Oh, we don't use WhatsApp with the court users. It's only internal. Yes, it's only internal. Yes. Yeah.
Yeah, because like I was thinking about the security wise, like if you do outside.
Oh, okay. No. We have had up to 200 court users in a Zoom session. So that's why we use that other court or that program, but it's just internally. It's just for court, for the court personnel. Yes.
So one more question. Like you are using Zoom, right?
Yes.
So do you try for Teams? Is there any reason why is Zoom?
Yeah. Not a diss to Teams or anything like that. We tried, because at the beginning, Judge Villarreal was the one paying for that license. As I mentioned, we started even before Zoom was a thing. I think Zoom started being a thing maybe 2-3 weeks after the pandemic shut down. We started that same Friday. He had the license. So what happened is, like a month after we started Zoom, the Office of Court Administration issued Zoom licenses to every single court in Texas, and the Texas pays for it. We tried Teams. We tried other platforms just to see what the difference was. And Zoom is just something that we were able, and we practiced a lot. We did a lot of trial and error and stuff. So at the beginning, and I'm sure it happened to everybody, I'm sure that everybody was working 15, 16-hour days, right, guys? That's how it was. So that's why we continue using Zoom. Well, yeah, I have a preference. Yes.
We are using, I'm from Mediation. We are using Teams. That's the reason I was asking you.
Oh, okay. Maybe I didn't have the whole feature of Teams, and maybe that's why we couldn't get it done how we like doing it in Zoom. But yeah. Now you tell me about Teams after the session.
Yeah.
So I have a question for both of you, actually. So reference YouTube. Are you using YouTube for felony and misdemeanor hearings?
Yes.
Okay. Do you have multiple streams going at once sometimes, or is it just one stream at a time?
I've had multiple streams going at one time. I've had 2 to 3 courts running at the same time, but you need to have different Zoom licenses.
Okay.
Yes.
Okay. And then this might be for both of you guys. So reference Zoom. Have you had any pushback from individual agencies, PD, state attorney, anything like that about the use of it? Or any legal pushback reference using it?
We did, and that's why we don't use it in New Hampshire. We use WebEx. We use Cisco WebEx for all of our remote hearings. Our IT department at the outset decided that Zoom didn't meet the necessary protocols after getting feedback from law enforcement. Zoom has since changed, but we were already so invested with the WebEx hearings. But we also don't use YouTube for our public streaming. Instead, what we do is each courtroom in the state of New Hampshire uses the same WebEx ID each day. So, and those are published on our website. So if anybody wants to join a hearing, they can log on to that WebEx hearing and view. They don't have to be a participant to the case.
Okay, and then last question about the virtual piece in general. Was there any pushback about just going virtual?
We did not have any pushback about going virtual because at the beginning of the pandemic, it was the only way we could keep going. What we are getting now is we're continuing to do a lot of remote hearings. We're getting a lot of pushback with the hybrid hearings, so that is going to be our focus going forward. I mentioned that some attorneys feel like they're missing out and that the other party has an advantage if they're in court while they appear remotely. But everyone sees the value in a hybrid hearing. So what I'm going to be focusing on is finding a better way to view the court. We've heard that sometimes in a Zoom, the camera is so far away from the bench, they may not even know who the judge is that's hearing the case. That the sound quality isn't always the best. So those are the things that we're going to work on to make hybrid hearings better so that we can get rid of the problems because everyone understands the value.
And in my case, at the beginning, there was a little bit of pushback, but I mean, people have to pay their bills, so either get with the program or not. And now, because of the hybrid hearings that we're having, that jury selection conference, we do see the seasoned attorney appear more in person because they're comfortable. That's how they had been practicing for years. But the general public, the court user, they love it. I've seen people log in from work. I've seen people, teachers don't have to take their day off. And if they're going through a divorce, they can just get their 5-minute break or whatever. And in our criminal misdemeanors, I mean, isn't the point that we want to reform individuals, that we want to make sure that these individuals go back into life and have a job and be a productive citizen? I've seen people logging in from construction sites. I've seen people logging in from, they're working in the oil fields and they have their hard hat on and they don't have to, these are, people that live sometimes in poverty and one day off work because they have to go to court for a misdemeanor, for a criminal trespass or whatever other thing. It does impact their lives. So as long as they're going to court and people are paying attention when their case is called, I think this is the best thing that could happen personally.
So at our court, we do use WebEx as well for everything, and we are still holding most of our hearings are remote. How do you handle, or do you have any ideas of how to handle things, especially exhibits being submitted by self-represented parties?
That's exactly why we signed a contract with Case Center, because we were having a very difficult time with exhibits. We had to have an electronic solution, and I know that it's been mentioned, you can upload exhibits. Our self-represented litigants get a link on their phone and they upload a photo of a car crash or a photo of anything they need, any documents. So that was our way of resolving that, was using Case Center.
So they're not specific just to Zoom. They will work with WebEx as well.
Oh, yes, absolutely. Absolutely.
Is there any digital storing for the exhibits?
Digital storage? Yes, everything is stored within the Case Center product. And we've got a contract with them that dictates, I think Judge Nicastro had mentioned, it mirrors our retention policy for exhibits. And they store it, it's stored in the cloud, and we don't have to worry about boxing exhibits and taking them to a storage facility anymore. Some of our courts ran out of storage, so we were having to transfer things to other courts. We don't have to worry about that anymore. They're all stored electronically.
What product you are using for the exhibits?
We're using Thomson Reuters Case Center.
Okay, thank
Yep.
you.
No, once again, thank you. Thank you to our reformers. Thanks, Karen. Thanks, Cecilia, for the time. And thank you all for participating. And hopefully this was valuable. Thank you.